I came home from a 2-week business trip to Denver to find my beautiful sage green Victorian house in Portland, Oregon, had been painted an aggressive shade of beige that looked like someone had mixed oatmeal with sadness. My hands started shaking as I pulled into the driveway, convinced I was looking at the wrong house until I saw my familiar oak tree, and the garden gnome collection my late grandmother had given me still positioned along the walkway. My name is Marcus Chen, and I had spent 3 years restoring that 1892 Victorian to its original color scheme based on historical records from the Portland archives. The sage green with cream trim and burgundy accents had won me a preservation award from the city just 8 months earlier. Now it looked like every other bland suburban box on the planet. I sat in my car for a solid 5 minutes, gripping the steering wheel and trying to process what I was seeing. Then I noticed the envelope tucked into my front door. I walked up the path like I was moving through water, each step feeling surreal. The paint job was fresh enough that I could still smell the fumes, and when I touched the porch railing, a tiny bit of beige came off on my finger. They had painted over everything, even the decorative millwork I had spent weeks hand restoring. The envelope contained an invoice from Cascade Painting Services for $8,347, along with a letter on Meadowbrook Estates' HOA letterhead. The letter was signed by Patricia Vanderbilt, HOA president, and it informed me in the most condescending tone possible that my house had been brought into compliance with community standards, and that payment was due within 30 days to avoid additional late fees and potential legal action. I read the letter 3 times, each time getting angrier. I had reviewed the HOA covenants, conditions, and restrictions carefully before buying the house 4 years ago. The neighborhood had been established in 1890, long before HOAs even existed, and the HOA had only been formed 15 years ago when a developer bought and renovated several properties on the eastern edge of the neighborhood. My street was part of the historic district, and I knew for a fact that there were provisions protecting historical accuracy in home restorations. I immediately went inside and pulled out my HOA documents. I spread them across my dining room table and read through every single page. The CC and Artiques stated that exterior paint colors required approval from the Architectural Review Committee, which I had received in writing 4 years ago when I first painted the house. There was absolutely nothing in the documents that gave the HOA the right to paint someone's property without permission, and certainly nothing that allowed them to bill the homeowner for it. My phone rang at 7 the next morning. I had barely slept, spending most of the night documenting everything with photographs and reviewing my files. The caller ID showed a number I did not recognize. "Mr. Chen, this is Patricia Vanderbilt from the Meadowbrook Estates HOA," a sharp voice announced without waiting for me to say hello. "I'm calling to discuss the recent improvements made to your property." "Improvements?" I kept my voice level, though my blood pressure was definitely not level. "You painted my house without my permission." "Your house was in violation of community standards," Patricia said, her tone suggesting she was talking to a particularly slow child. "We sent you multiple notices about the unapproved color scheme." "I never received any notices, and my color scheme was approved 4 years ago." "I have the written approval from your Architectural Review Committee. That approval was issued under the previous administration and is no longer valid. The current board implemented new color guidelines 18 months ago. All homes must now be painted in neutral earth tones from our approved palette. Your green was, quite frankly, an eyesore that was negatively impacting property values." I took a deep breath, counting to 5. "Even if what you're saying is true, which I dispute, you had no right to paint my property without my consent. That's vandalism at minimum, possibly criminal trespass." Patricia laughed, actually laughed. "Mr. Chen, I suggest you read your HOA documents more carefully." The board has the authority to make necessary improvements to maintain community standards and bill homeowners for the cost. You have 30 days to pay the invoice or we'll place a lien on your property. Good day. She hung up before I could respond. I stood there holding my phone, absolutely furious. I had dealt with difficult people in my career as a project manager for a tech company, but this was a whole new level of audacity. I called my neighbor, Sarah Rodriguez, who had lived in the neighborhood for 20 years. She answered on the third ring, and I could hear her kids arguing in the background. "Marcus, I was wondering when you'd get back. I tried to stop them, I really did," Sarah said, sounding genuinely distressed. "They showed up last Tuesday with a whole crew and just started painting. I told them you weren't home and hadn't approved anything, but Patricia said they had the authority to proceed. I took some photos and videos if you need them." "I definitely need them. Sarah, did you get any notices about new color requirements?" "Oh yeah, about a year and a half ago. They sent out this big packet with paint chips and said everyone had to repaint within 2 years if their current colors weren't on the approved list. My house was already tan, so I didn't have to do anything. But Marcus, your house was gorgeous. Everyone on the street loved it." "This is absolutely insane. Did anyone else have to repaint?" The Johnsons at the end of the block had a blue house. They fought it for a while but eventually gave in and painted it gray. I think they were worried about the legal costs of fighting the HOA. But they at least got to choose when and how it was done. I've never heard of the HOA just painting someone's house without permission. After talking to Sarah, I spent the morning calling every other neighbor I knew. The pattern became clear pretty quickly. Patricia Vanderbilt had taken over as HOA president 2 years ago and had immediately started implementing strict new rules. The previous president, a retired teacher named George Martinez, had run the HOA with a light touch, focusing on actual community needs like street maintenance and the neighborhood park. Patricia had a very different vision. According to my neighbor Tom Wilson, Patricia had moved to Portland from a planned community in Arizona and seemed determined to transform our historic neighborhood into the same kind of sterile, controlled environment. She had implemented rules about lawn height, Christmas decoration dates, acceptable mailbox styles, and a host of other nitpicky requirements. The paint color mandate had been her biggest push, supposedly to increase property values and maintain neighborhood aesthetics. I called the city's Historic Preservation Office next. A helpful woman named Jennifer looked up my property records while I waited on hold. "Mr. Chen, your property is definitely within the Alphabet Historic District," Jennifer confirmed. "You received a certificate of appropriateness for your exterior paint colors in 2021, and that approval doesn't expire. The colors you chose are consistent with the period and style of your home. Does the HOA have some issue with it?" "The HOA painted my house a different color while I was out of town and sent me a bill for over $8,000. There was a long pause. "I'm sorry, could you repeat that?" I explained the situation in detail. Jennifer sounded increasingly concerned as I talked. "Mr. Chen, that's a serious problem. Properties in historic districts have protections that supersede HOA regulations. The HOA cannot require you to paint your house in a way that contradicts the historic preservation guidelines, and they certainly cannot alter your property without your consent. I'm going to send you some documentation that may help. You should also file a complaint with our office about the unauthorized alteration of a historic property. Can the city make them restore it to the original colors? We can definitely pursue enforcement action. I'll need to get our legal team involved. Can you send me photographs of the property before and after?" I spent the next hour emailing photos and documentation to Jennifer. Then I started researching attorneys who specialized in HOA disputes. I had never sued anyone in my life and had always believed in solving problems through communication and compromise. But Patricia's attitude and the sheer audacity of what the HOA had done made it clear that reasonable discussion was not going to be an option. I found an attorney named Rebecca Lawson who had excellent reviews and significant experience with HOA cases. Her office was in downtown Portland, and she had an opening that afternoon due to a cancellation. Rebecca was in her mid-40s with short gray hair and sharp eyes that missed nothing. Her office walls were covered with framed letters from grateful clients and what appeared to be several awards for consumer advocacy work. Mr. Chen, I've seen a lot of HOA overreach in my career, but this is genuinely shocking, Rebecca said after I explained the situation and showed her all my documentation. They didn't just violate your property rights. They may have committed criminal trespass, vandalism, and fraud. The fact that they're trying to bill you for it adds another layer of audacity. Can we sue them? Absolutely. We can file a lawsuit for damages, including the cost to restore your house to its original condition, compensation for the violation of your property rights, and potentially punitive damages. But here's what I'm thinking might be even more effective. Rebecca leaned forward, a slight smile on her face. We let them sue you first. I must have looked confused because Rebecca continued, they've threatened to put a lien on your property if you don't pay. To do that, they'll likely have to take you to court. Let them make the first move and put their position on the record in a legal proceeding. Then we file a counterclaim that will blow their case apart. Judges do not like it when HOAs abuse their power, and they really don't like it when people damage property without authorization. How long will this take? HOA cases can move fairly quickly, usually a few months to a year depending on the court's schedule. In the meantime, I'd recommend not paying them anything and documenting every interaction you have with the HOA. Also, get estimates for restoring your house to the original colors. I left Rebecca's office feeling better than I had since discovering the paint job. At least I had a plan and someone on my side who understood the law. 3 days later, I received a formal demand letter from the HOA's attorney, a firm called Morrison & Associates. The letter reiterated the demand for payment and stated that failure to pay within 20 days would result in a lien and possible foreclosure proceedings. The tone was threatening and aggressive, clearly designed to intimidate me into compliance. I forwarded it to Rebecca, who sent back a brief reply telling me not to worry and that everything was proceeding as expected. I spent the next 2 weeks getting estimates for repainting the house. Every contractor I spoke to had the same reaction. Shock that an HOA had done this, followed by outrage at the quality of the paint job. Cascade Painting Services had apparently rushed through the work, using cheap paint and doing minimal surface preparation. One contractor, a guy named Mike who specialized in historic renovations, pointed out at least a dozen places where they had painted over rotted wood, loose trim, and even a wasp nest. This is garbage work, Mike said, shaking his head as we walked around the house. They didn't scrape, didn't prime properly, and this paint is going to start peeling within a year. Also, they painted over your original decorative details. See here? He pointed to an ornate bracket under the eave. This had multiple colors originally to highlight the different elements. Now it's just all beige. Restoring this properly is going to cost way more than their invoice because we'll have to strip all this cheap paint off first. Mike's estimate to properly restore the house came to $22,000. 2 other contractors gave me similar numbers. The highest estimate was $26,000. I also discovered something interesting while reviewing the HOA's recent activities. Using public records requests, I obtained copies of the HOA board meeting minutes for the past 2 years. The new paint color policy had been approved in a meeting where only 3 of the 7 board members were present, barely making quorum. The vote was 2 in favor and 1 opposed. The meeting minutes showed almost no discussion of how the policy would affect historic properties, or what the enforcement mechanism would be. More interesting, I found that Patricia Vanderbilt's sister-in-law owned Cascade Painting Services. That information came from Sarah, who had done some Facebook stalking after I mentioned the painting company. Patricia's sister-in-law, Deanne Thompson, had started the company 3 years ago. According to their business records, about 60% of their revenue over the past 18 months had come from Meadowbrook Estates' HOA projects. Rebecca was thrilled when I shared this information. This gets better and better. Not only did they damage your property without authorization, but there's a clear conflict of interest. Patricia is funneling HOA business to her sister-in-law's company. I bet if we dig deeper, we'll find other homeowners who were forced to use cascade painting. Sure enough, when Sarah helped me put out feelers in the neighborhood, we found 6 other homeowners who had been required to repaint their houses. 4 of them had used cascade painting services after Patricia strongly recommended them at HOA meetings. The 2 who had used other contractors reported that Patricia had made their lives difficult with petty violations and constant complaints. One of those homeowners, a retired veteran named James Patterson, was particularly angry about his experience. "She harassed me for months," James told me over coffee at a local cafe. "First it was the paint, then she decided my lawn was too long, then my mailbox was the wrong style. I finally used her sister-in-law's company just to get her off my back, but they did a terrible job. I had to hire another contractor to fix their mistakes, cost me an extra $3,000. Did you know they were related? Not until afterwards. If I'd known, I would have raised hell about the conflict of interest, but by then I was just exhausted from fighting with her." The 20-day deadline passed without me paying the invoice. 5 days later, I received a notice that the HOA had filed a lawsuit against me in Multnomah County Circuit Court seeking payment of the invoice plus late fees, interest, and attorney fees, totaling just over $10,000. Rebecca and I had been expecting this. We had already prepared a detailed counterclaim that we filed the same week. My counterclaim sought damages for trespass, conversion of property, breach of fiduciary duty, fraud, and violation of Oregon's historic preservation statutes. We asked for the full cost of restoration, $26,000 based on the highest estimate, plus compensatory damages for loss of use and enjoyment of my property, emotional distress, and punitive damages. We also requested attorney fees and asked the court to remove Patricia from the HOA board for breach of fiduciary duty due to the conflict of interest. The total amount we were seeking was $150,000. I'll admit, when Rebecca first told me the number, I thought it was excessive. But she explained that punitive damages are meant to punish wrongdoing and deter future bad behavior, and that Patricia's actions were egregious enough to warrant significant punishment. "We might not get everything we ask for," Rebecca said, "but we want to make it clear to the judge just how serious this is. The HOA violated your fundamental property rights and did so while enriching a board member's family. That's the kind of behavior that needs to be punished." The HOA's response to our counterclaim was delayed by 2 weeks, which Rebecca said was a good sign. "They're scrambling," she explained. "They thought you'd either pay up or file a simple objection. Instead, we've hit them with a comprehensive counterclaim that exposes all their wrongdoing. Their attorney is probably having some very uncomfortable conversations with Patricia right now." When the response finally came, it was clear that Morrison and Associates was taking the case more seriously. They denied all our allegations and argued that the HOA had acted within its authority under the CC and Artiques. They claimed I had received proper notice of the paint color policy change and had been given adequate time to comply before the HOA took action. They also argued that the historical preservation approvals were irrelevant because HOA rules supersede city regulations. Every single one of those arguments was false, and we had documentation to prove it. The discovery phase of the lawsuit was illuminating. Through formal discovery requests, we obtained the HOA's complete financial records, all board meeting minutes, correspondence related to the paint color policy, and communications between Patricia and Cascade Painting Services. The records showed a pattern of self-dealing that went beyond just my house. Over the past 18 months, the HOA had paid Cascade Painting Services over $90,000 for various projects. In several cases, the projects had been approved by Patricia as emergency maintenance without requiring full board votes. The invoices were consistently higher than market rates for similar work. We also found the smoking gun regarding notice. The HOA's records showed that notice letters about the paint color policy had been sent to all homeowners in September 2 years ago. However, the mailing list they used was outdated. My notice had been sent to the previous owner of my house, who had moved to Seattle. I had never received any communication about the policy change. More damaging, the records showed that Patricia had specifically targeted my house. In board meeting minutes from 6 months ago, she was quoted as saying my garish Victorian colors were dragging down the neighborhood and that she was exploring options for enforcement. 3 months later, there was a brief note that the board had authorized corrective action on my property. The vote was 3-1 with 3 board members not present. Rebecca deposed Patricia, which I was allowed to attend. Watching Patricia squirm under Rebecca's questioning was immensely satisfying, though I kept my face neutral the whole time. Mrs. Vanderbilt, can you explain your relationship with Deanne Thompson, the owner of Cascade Painting Services? Rebecca asked. She's my sister-in-law, Patricia admitted, clearly unhappy about it. Did you disclose this relationship to the HOA board before recommending her company for projects? It may have come up at some point. May have. According to the board meeting minutes, there's no record of you ever disclosing this conflict of interest. In fact, you repeatedly recommended Cascade Painting Services without mentioning your family connection. Patricia's attorney objected, but the damage was done. Did you personally profit from the HOA's contracts with Cascade Painting Services? Absolutely not. That would be completely inappropriate. But your sister-in-law's company profited significantly, correct? Nearly $90,000 over 18 months from HOA contracts you approved or recommended. Patricia's face was red. The company did good work at competitive prices. Did you obtain competing bids for these projects? Silence. Mrs. Vanderbilt, did you obtain competing bids before awarding contracts to your sister-in-law's company? Not always. For smaller projects, the process would have been too burdensome. Rebecca pulled out a document. But the HOA's own policies require competitive bids for any project over $2,000, correct? Yes, but there are exceptions for emergency work. How many of the Cascade Painting Services projects were actual emergencies? Patricia couldn't provide a good answer to that. The deposition continued for 3 hours, and by the end, Patricia's story had more holes than Swiss cheese. She contradicted herself multiple times, couldn't explain why I hadn't received notice of the policy changes, and ultimately admitted that she had authorized the painting of my house without verifying whether I had been properly notified of the violation. We also deposed Deanne Thompson, the owner of Cascade Painting Services. She was more forthcoming than Patricia, possibly because she was starting to realize that her business could be in serious jeopardy. Mrs. Thompson, did your sister-in-law Patricia Vanderbilt ever discuss HOA matters with you outside of official business contexts? Rebecca asked. Sometimes. We're family, we talk about work stuff. Did she ever tell you which properties would be requiring paint work before those decisions were officially announced? Deanne hesitated, glancing at her attorney. Possibly. I don't really remember specific conversations. Let me refresh your memory. We have text messages between you and Mrs. Vanderbilt where she tells you that several properties will need to be repainted and suggests you prepare bids. These texts were sent before the HOA officially notified the homeowners of any violations. Does that refresh your memory? The text messages had been obtained through Patricia's phone records during discovery. Deanne had been smart enough or paranoid enough to delete her side of the conversations, but Patricia had kept everything. Diane's face went pale. I guess Patricia might have mentioned some things. Did you give Mrs. Vanderbilt any financial benefits in exchange for these favorable contracts? Gifts, money, discounts on personal painting work? No, nothing like that. Did you paint Mrs. Vanderbilt's personal residence last summer? Yes, but she paid full price, did she? According to your business records, you charged her $4,200 for exterior painting of a 3,000 square foot house. That's substantially below your usual rates. In fact, it's about half what you charged Mr. Chen for his house, which is slightly smaller. Deanne didn't have a good answer for that either. The evidence we gathered during discovery was damning. Rebecca filed a motion for summary judgment, arguing that the undisputed facts showed the HOA had violated my rights and that we should win without even going to trial. The HOA opposed the motion, but their arguments were weak. The hearing on the motion for summary judgment was scheduled for a Tuesday morning in late September, about 5 months after I had first discovered the unauthorized paint job. I took the day off work and wore my best suit to court. The courtroom was smaller than I expected, with wood paneling and uncomfortable benches. Judge Maria Hernandez presided, a woman in her early 60s with a reputation for being tough but fair, according to Rebecca. The HOA's attorney, a middle-aged man named Donald Morrison, argued first. He claimed that the HOA had acted reasonably to enforce its rules and maintain property values, that I had been properly notified of the violations, and that the HOA's authority under the CC and Artiques gave them the right to take corrective action. Judge Hernandez listened without expression, occasionally making notes. Then Rebecca stood up to argue our side. She methodically destroyed every one of Morrison's arguments, citing specific evidence from discovery. She displayed the mailing records showing my notice had been sent to the wrong address. She showed the text messages between Patricia and Diane proving the conflict of interest. She presented testimony from contractors about the poor quality of the work and the excessive cost I would incur to fix it. Your Honor, this is not a case of an HOA reasonably enforcing its rules, Rebecca said. This is a case of an HOA president abusing her power to funnel money to her sister-in-law's business while violating homeowners' fundamental property rights. Mr. Chen's house is in a historic district. He received proper city approval for his paint colors. The HOA cannot override historic preservation laws. More importantly, the HOA had no right to paint his house without permission. That's basic property law. You cannot alter someone's property without their consent, no matter what your HOA documents say. Judge Hernandez asked several pointed questions, mostly directed at Morrison. He struggled to answer them satisfactorily. Counselor, how do you justify painting someone's house without verifying they received notice of the alleged violation? The judge asked. Your Honor, the HOA followed its standard notice procedures. But those procedures failed, did they not? The notice went to the wrong address. That was an unfortunate clerical error, but it doesn't change the fact that Mr. Chen was in violation of the HOA rules. Even if he was in violation, which I'm not conceding, does the HOA have the right to alter someone's property without permission? Morrison pulled out a copy of the CC and Artiques. Your Honor, Section 7.3 of the CC and Artiques states that the HOA may take necessary action to bring properties into compliance and assess the costs to the homeowner. Does it specifically authorize the HOA to physically alter a homeowner's property without consent? Morrison hesitated. It authorizes necessary action to enforce compliance. That's not what I asked, Counselor. Show me the specific language that authorizes painting someone's house without permission. Morrison flipped through the document, clearly struggling. Your Honor, the provision gives the HOA broad authority to enforce compliance. Broad authority is not unlimited authority, Counselor. And even if such authority existed in the CC and Artiques, which I doubt, it would likely be unenforceable as contrary to public policy and property law. Judge Hernandez took the motion under advisement, which meant she would issue a written decision later rather than ruling from the bench. Rebecca told me this was normal and that based on the judge's questions, she was cautiously optimistic. 2 weeks later, we received Judge Hernandez's decision. It was 12 pages long and absolutely scathing toward the HOA. The judge granted our motion for summary judgment on liability, finding that the HOA had committed trespass, conversion, and breach of fiduciary duty. She found that the HOA's notice procedures had failed, and that even if they had not failed, the HOA had no authority to paint my house without permission. She specifically noted that the CC and Artiques did not contain any provision explicitly authorizing physical alteration of a homeowner's property. Judge Hernandez also found that Patricia had violated her fiduciary duty as HOA president by funneling contracts to her sister-in-law's company without proper disclosure or competitive bidding. The judge wrote that this apparent self-dealing was exactly the kind of behavior that HOA laws were designed to prevent. The only issue remaining for trial was the amount of damages. Judge Hernandez scheduled a one-day bench trial for November to determine the specific damages I should receive. The HOA tried to settle after the judge's ruling came out. Morrison called Rebecca and offered to pay for repainting the house if I would drop the rest of my claims. Rebecca countered by demanding full restoration costs, attorney fees, and $50,000 in additional damages. Morrison balked at that and said he would need to consult with his clients. A week later, Morrison called back with a revised offer of $40,000 total to settle everything. Rebecca told me it was a reasonable offer that would avoid the uncertainty of trial, but that she thought we could do better if we pushed forward. "It's your call," Rebecca said. "$40,000 covers your restoration costs and a decent chunk of my fees plus some extra. But I think the judge is on our side, and we might be able to get significantly more, including punitive damages. The risk is that we could also get less." I thought about it for a couple of days. Part of me wanted to take the money and be done with it. The whole situation had been stressful and time-consuming, but another part of me was still angry about what Patricia had done. She needed to face real consequences, or she would just continue abusing her power. "Let's go to trial," I told Rebecca. "This isn't just about money anymore. It's about accountability." The trial was set for November 15th. In the weeks leading up to it, Rebecca and I prepared extensively. We organized all our evidence, prepared our witnesses, and drafted our arguments about damages. The morning of trial, I arrived at the courthouse early. The same courtroom, the same uncomfortable benches. Patricia was there with Morrison, looking nervous and angry. Our eyes met briefly, and she looked away first. Judge Hernandez called the trial to order at 9 o'clock sharp. Since liability had already been established, we were only there to determine damages. Rebecca called me as the first witness. I testified about discovering the paint job, my shock and anger, the process of trying to resolve the situation, and the impact it had on my life and my enjoyment of my home. "Mr. Chen, can you describe the significance of the original paint colors to you?" Rebecca asked. "I spent months researching the history of my house," I explained. "I went through old photographs, city records, even interviewed the grandchildren of the original owners. The sage green and burgundy colors were part of the original 1892 design. Restoring them accurately was a labor of love. When I finished, the house looked the way it was meant to look, the way it had looked when it was first built. The city recognized that work with a preservation award." "How did you feel when you saw what the HOA had done?" "Devastated. It felt like someone had vandalized a work of art. All that research, all that careful work, just painted over with cheap beige paint. And it wasn't just about the aesthetics. The house is my home. It's where I plan to raise a family someday. Having someone alter it without permission felt like a violation." Morrison cross-examined me, trying to suggest I was exaggerating my emotional distress and that the new paint job was perfectly acceptable. He didn't make much headway. Next, Rebecca called Mike, the contractor who specialized in historic renovations. He testified about the poor quality of Cascade Painting Services work and the cost and difficulty of properly restoring the house. In your professional opinion, what will it cost to restore Mr. Chen's house to its original condition? Rebecca asked. Between $22,000 and $26,000, Mike said. The complication is that we have to strip off all the new paint first because it was applied improperly. That adds significant time and cost. If they had done the job right the first time, repainting would only cost $8,000 to $10,000, but they rushed through it and used cheap materials. Is there any other damage you observed? Yes. They painted over several areas where the original wood was rotting or damaged. Proper procedure would be to repair those areas first, then paint. By painting over the damage, they've actually made the underlying problems worse. Mr. Chen will need to do some wood repair and replacement in addition to the repainting. Morrison tried to suggest that any wood damage was pre-existing and not the HOA's fault, but Mike shut that down quickly by noting that proper contractors would have flagged the issues before painting. Rebecca then called Jennifer from the Historic Preservation Office, who testified about the significance of the Historic District designation and how my original paint colors were appropriate for the period and style of the house. Does the HOA's alteration of Mr. Chen's house violate any city ordinances? Rebecca asked. Yes, property owners in historic districts are required to maintain the historic character of their properties. Unauthorized alterations can result in fines and enforcement action. In this case, the HOA caused Mr. Chen to be out of compliance through no fault of his own. For our final witness, Rebecca called a forensic accountant who had analyzed the HOA's financial records. He testified about the payments to Cascade Painting Services and the lack of competitive bidding. In your professional opinion, did the HOA overpay for the painting of Mr. Chen's house? Rebecca asked, substantially. Based on market rates for similar work, a reasonable cost would have been $5,000 to $6,000. The HOA was charged over $8,000. Given the poor quality of the work, even $5,000 would have been too much. Morrison objected, arguing that the quality of the work was subjective. Judge Hernandez overruled the objection, noting that multiple contractors had testified about quality issues. The HOA's case was brief. Morrison called Patricia as a witness. She testified that she had been trying to improve the neighborhood and maintain property values, and that she had no intention of harming me or violating my rights. Mrs. Vanderbilt, why did you think it was appropriate to paint Mr. Chen's house without his explicit permission? Rebecca asked on cross-examination. The HOA rules gave us the authority to enforce compliance. His house had been in violation for months after the deadline passed. But you knew he hadn't received notice of the violation, didn't you? I knew the notice had been sent to the address on file. That's not what I asked. You personally confirmed that the notice had been sent to the wrong address before authorizing the painting, didn't you? Patricia hesitated. I may have been aware that there was a mailing issue. So you knew Mr. Chen hadn't received notice, and you ordered his house painted anyway. The rules had been publicized at HOA meetings and in newsletters. Mr. Chen was out of the country on business during several of those meetings, wasn't he? And the newsletters were also mailed to the wrong address. Patricia didn't have a good answer. Rebecca hammered her on the conflict of interest issues as well, getting Patricia to admit that she had never disclosed her relationship with Diane to the full HOA board and had never obtained competitive bids for most of the Cascade Painting Services contracts. Morrison called no other witnesses. His closing argument focused on the idea that the HOA had made honest mistakes but had not acted with malicious intent, and therefore punitive damages were inappropriate. Rebecca's closing argument was powerful. She walked through all the evidence of the HOA's wrongdoing, Patricia's self-dealing, and the impact on me. She argued that substantial punitive damages were necessary to deter future abuse of power. "Your Honor, this case is about more than just paint," Rebecca said. "It's about the fundamental right to control your own property. It's about the duty of fiduciaries to act in the best interests of those they serve, not to enrich themselves and their families." Patricia Vanderbilt abused her position for personal benefit and violated Mr. Chen's rights in the process. If that behavior goes unpunished, what message does it send to other HOA boards? The court has an opportunity here to make clear that this kind of conduct will not be tolerated. Judge Hernandez took a brief recess to review her notes, then returned to deliver her ruling from the bench. "I've heard all the evidence and considered the arguments of both sides," the judge began. "Let me be clear about what happened here. Mr. Chen purchased a historic home and invested significant time and money in restoring it accurately and appropriately. His work was recognized by the city with a preservation award. The HOA, under Mrs. Vanderbilt's leadership, decided that Mr. Chen's historically accurate paint colors were not acceptable under their new rules. Rather than engage in good faith efforts to resolve the issue, rather than verify that Mr. Chen had been properly notified, the HOA took the drastic and inappropriate step of painting his house without permission." The judge paused, looking directly at Patricia. "Mrs. Vanderbilt, your testimony today confirmed that you knew there were problems with the notice process, but you proceeded anyway. You authorized spending HOA funds on a project performed by your sister-in-law's company without proper disclosure or competitive bidding. Your conduct violated your fiduciary duty to the HOA members and violated Mr. Chen's property rights." Judge Hernandez turned back to her notes. "As to damages, I find that Mr. Chen is entitled to the full cost of restoration. I'm using the middle estimate of $24,000. I'm also awarding compensatory damages of $10,000 for loss of use and enjoyment of his property and emotional distress." The evidence clearly showed that Mr. Chen's carefully restored home had deep personal significance to him, and the unauthorized alteration caused genuine harm. I felt a surge of relief and vindication. "Finally, I'm awarding punitive damages of $75,000, Judge Hernandez continued. "This award is intended to punish Mrs. Vanderbilt and the HOA for their egregious conduct and to deter similar behavior in the future. The self-dealing, the disregard for proper notice, and the fundamental violation of property rights all justify a substantial punitive award." I did the math in my head. 24,000 plus 10,000 plus 75,000 was $109,000. "In addition," the judge said, "Mr. Chen is entitled to recover his reasonable attorney fees and costs under Oregon's HOA statutes. The parties will need to submit fee petitions for my review, but based on the complexity of this case and the excellent work by Mr. Chen's counsel, I anticipate a substantial fee award. Finally, I'm ordering that the HOA remove Patricia Vanderbilt from the board of directors immediately. Her conduct has shown that she is not fit to serve in a fiduciary capacity. The HOA must elect a new president within 30 days. Patricia looked like she had been slapped. Morrison was frantically taking notes. "The HOA has 60 days to pay the judgment," Judge Hernandez concluded. "If payment is not made within that time, Mr. Chen may pursue collection remedies. This court is adjourned." I shook Rebecca's hand, then hugged her. "We did it. You did it," Rebecca said. "You stood up for yourself when a lot of people would have just paid the bill and moved on. You should be proud." Outside the courtroom, Patricia tried to rush past me, but I stopped her. "Mrs. Vanderbilt, I hope you learned something from this," I said calmly. She glared at me. "You just destroyed the HOA's finances over paint colors. I hope you're happy." "No, you destroyed the HOA's finances by abusing your power and enriching your family. I just held you accountable." Patricia stormed off without responding. Morrison followed her, looking tired. The aftermath of the trial was almost as interesting as the trial itself. Rebecca submitted a fee petition requesting $65,000 in attorney fees and costs. The HOA objected, claiming the amount was excessive, but Judge Hernandez approved the full amount 2 weeks later. The total judgment, including fees and costs, came to $174,000. The HOA's insurance covered some of it, but the policy had a $50,000 deductible and excluded punitive damages, so the HOA was on the hook for about $100,000. The HOA had to take out a loan to pay the judgment, which they did just before the 60-day deadline. The check arrived via certified mail, and I deposited it the same day. But the story doesn't end there. The publicity from the case led to a deeper investigation of the HOA's finances. Several homeowners who had been forced to use Cascade painting services filed a complaint with the Oregon Department of Justice Consumer Protection Division, alleging that Patricia had engaged in a pattern of self-dealing. The state opened an investigation. 2 months after the trial, the Attorney General's office filed civil charges against Patricia and Deanne for violations of Oregon's nonprofit corporation laws and consumer protection statutes. The charges alleged fraud, breach of fiduciary duty, and unjust enrichment. Rather than fight the charges, Patricia and Deanne agreed to a settlement. Patricia was banned from serving on any HOA board in Oregon for 10 years and was required to pay a $25,000 fine. Deanne's company was required to refund $20,000 to affected homeowners and was placed under monitoring by the state for 2 years. But the criminal justice system was not finished with them yet. One of the homeowners we had interviewed during my case, James Patterson, filed a complaint with the Portland Police Bureau alleging that Patricia had coerced him into using Cascade painting services through harassment and threats of escalating HOA fines. The police investigation uncovered evidence that Patricia had engaged in similar conduct with multiple homeowners. The Multnomah County District Attorney's Office reviewed the evidence and decided to file criminal charges. Patricia was charged with 2 counts of coercion and 3 counts of official misconduct. Deanne was charged as an accomplice on some of the coercion charges. I had to testify at the criminal trial, which took place almost a year after my civil trial. The criminal trial was more intense, with a jury instead of just a judge. The prosecution presented evidence of Patricia's pattern of targeting homeowners who refused to use Cascade painting services, threatening them with fines and liens, and making their lives miserable until they complied. The jury deliberated for 6 hours before returning guilty verdicts on all charges against Patricia. Deanne was convicted on 1 count of coercion, but acquitted on the others. Patricia was sentenced to 2 years in prison, with all but 6 months suspended. She was also ordered to perform 200 hours of community service and pay restitution to the affected homeowners. Deanne received a suspended sentence and probation. Watching Patricia being led out of the courtroom in handcuffs was surreal. I had never wanted to destroy anyone's life. I just wanted justice for what had been done to my house. But Patricia's actions had gone far beyond my case, and she had victimized multiple homeowners. The criminal conviction was the justice system's way of saying that kind of abuse of power would not be tolerated. As for my house, I hired Mike and his crew to restore it properly. The work took 3 weeks, but when they finished, my beautiful Victorian was back to its original sage green with cream trim and burgundy accents. I stood on the sidewalk looking at it the day the work was completed, and I felt something like peace settle over me. The neighborhood threw a block party to celebrate. Sarah organized it, and about 30 neighbors showed up with food and drinks. Everyone wanted to hear the story of how I had taken down Patricia and the HOA. "You're a hero, man," Tom Wilson said, clapping me on the back. "She was making all our lives miserable. Now the new board is actually reasonable and focused on real issues instead of stupid stuff like paint colors." The new HOA president was George Martinez, the retired teacher who had run the HOA before Patricia took over. He had been elected by acclamation at an emergency meeting after Patricia was removed by the court. One of his first acts was to rescind the paint color policy and restore the previous, more relaxed rules. "We're a historic neighborhood," George said at the block party. "We should celebrate that, not try to turn every house into a beige box. If someone wants to paint their Victorian house pink with purple trim and the Historic Preservation Office approves it, that's their right." George approached me later in the evening as the party was winding down. "Marcus, I want to thank you for what you did. I know it was stressful and expensive even though you won in the end, but you stood up for all of us. Patricia was destroying this neighborhood with her petty tyranny. You stopped her." "I just wanted my house back," I said honestly. "Well, you got your house back and you saved the neighborhood in the process. That's worth celebrating." 6 months after the criminal trial, I received an unexpected letter from Patricia. It was postmarked from Coffee Creek Correctional Facility, the women's prison where she was serving her sentence. I almost threw it away without reading it, but curiosity got the better of me. The letter was handwritten on plain white paper. Patricia's handwriting was neat and controlled, just like her personality had seemed before everything fell apart. "Dear Mr. Chen," the letter began, "I am writing to apologize for what I did to your house and for the way I treated you throughout this process. I have had a lot of time to think about my actions and the consequences they have had, not just for you but for many people in the neighborhood. I was wrong. I let my desire for control and my belief that I knew what was best for the neighborhood blind me to the rights of individual homeowners. I also let my relationship with my sister-in-law compromise my judgment and my duty to the HOA members. I am not asking for your forgiveness, as I know I do not deserve it. I simply wanted you to know that I understand what I did was wrong and I am sorry. Sincerely, Patricia Vanderbilt." I read the letter twice, trying to decide how I felt about it. Part of me was skeptical. Prison apologies are easy. Real remorse is harder to judge. But another part of me appreciated the gesture, even if it was overdue and possibly self-serving. I never responded to the letter. Some things don't require a response. Life gradually returned to normal. My job kept me busy, and I started dating a woman named Lisa I met through a mutual friend. She loved the house and the story behind it, though she was horrified by what Patricia had done. We spent weekends working in the garden and refinishing the hardwood floors inside. The HOA under George's leadership was everything an HOA should be: practical, reasonable, and focused on actual community needs. They maintained the common areas, organized neighborhood events, and handled disputes without drama. The difference between George's approach and Patricia's was night and day. About a year after the criminal trial, I ran into Deanne at a local hardware store. We both froze when we saw each other. She looked older and more tired than I remembered. "Mr. Chen," she said quietly, "I owe you an apology. What Patricia and I did was wrong. I've lost most of my business because of it, and I deserve that. I just wanted you to know that I'm sorry." "I appreciate that," I said. I didn't know what else to say. For what it's worth, I never wanted to paint your house. Patricia pushed for it, said it would be good for business. I should have said no. "Yes, you should have." Deanne nodded and walked away. I watched her go, feeling a complicated mix of emotions. She had been complicit in Patricia's schemes, but she had also been manipulated and used. There was enough blame to go around. 2 years after the original incident, I was contacted by a reporter from the Oregonian who was writing a series on HOA abuses. She had heard about my case and wanted to interview me. I agreed, figuring that publicity might help prevent similar situations in the future. The article came out a month later, featuring my story prominently along with several other cases of HOA overreach from around the state. The headline read, "When HOAs Go Rogue, How Homeowners Are Fighting Back Against Abuse of Power." My house was featured in a large color photograph, showing the beautiful restored Victorian colors. The article sparked a conversation in Oregon about HOA regulations and accountability. Several state legislators proposed new laws to strengthen homeowner protections and increase transparency requirements for HOA boards. I was even invited to testify before a legislative committee, which was an experience I never expected to have. The legislation passed a year later. It required HOAs to carry adequate insurance, prohibited board members from having financial interests in companies that contracted with the HOA, and created stronger notice requirements for rule changes and enforcement actions. The law also made it easier for homeowners to challenge HOA actions and recover attorney fees when they prevailed. I like to think that what happened to me helped make things better for other homeowners, even though I never set out to be an activist or reformer. I just wanted my house painted the right color. Patricia was released from prison after serving 5 months of her 6-month sentence. I heard through the neighborhood grapevine that she moved to California to live with relatives. I hope she found some peace and learned from her mistakes. Despite everything, I don't hate her. What she did was wrong, and she deserved to be held accountable, but I believe people can change. 5 years after the whole ordeal, Lisa and I got married in the backyard of my Victorian house. The sage green, cream, and burgundy colors made a beautiful backdrop for the wedding photos. About 75 people attended, including many of my neighbors who had supported me through the legal battles. George gave a toast at the reception, joking that our neighborhood had survived Patricia Vanderbilt and would probably survive anything. Everyone laughed, but there was truth in the humor. The neighborhood was stronger and more united because of what we had been through together. As I look at my house now, I don't see the violation anymore. I see a home full of happy memories. I see the place where Lisa and I started our life together. I see the careful restoration work that honors the craftsman who built the house in 1892. And yes, I see the victory over someone who tried to take my rights away. The whole experience taught me important lessons about standing up for yourself, about the importance of documentation and evidence, and about the power of persistence. It also taught me that HOAs can be forces for good or evil depending on who's running them, and that accountability matters. I never wanted to be the guy who sued his HOA, but I'm glad I did. Some battles are worth fighting, not just for yourself but for everyone who comes after you. My house stands as a reminder of that principle, painted in historically accurate colors that no HOA will ever change again without my permission. The final twist came 7 years after the original incident. I received a call from Rebecca Lawson, my attorney, who I hadn't spoken to in a couple of years. "Marcus, you're not going to believe this," she said. "Remember Patricia Vanderbilt? Of course. What about her? She's written a book about her experiences. It's about HOA governance and the importance of respecting homeowner rights. She's apparently become an advocate for HOA reform." I was stunned. "You're kidding." "Nope, it's being published next month. I got an advance copy because she mentions your case extensively." She portrays herself as someone who made serious mistakes and learned from them. It's actually pretty well written and insightful. She's donating all the proceeds to an organization that provides legal assistance to homeowners in HOA disputes. Wow, I don't know what to say to that. You don't have to say anything, but I thought you'd want to know. People can change, I guess. After hanging up with Rebecca, I sat on my front porch, looking at my house and thinking about the strange journey that had brought me to this point. Life has a way of surprising you. Sometimes the villains find redemption. Sometimes standing up for yourself changes more than just your own situation. Sometimes a dispute over paint colors becomes something much bigger and more important. I never did read Patricia's book, though Lisa bought a copy out of curiosity. She told me it was honest and self-critical, and that Patricia spent several chapters analyzing what had gone wrong in her thinking and behavior. Apparently, prison and therapy had given her perspective on how she had let her need for control, and her poor boundaries with her sister-in-law lead her into criminal behavior. Good for her, I thought. Redemption is possible for anyone willing to do the work. As for me, I'm just glad to be living in my beautiful Victorian house with my wife, enjoying the neighborhood and the community we've built. The whole experience is now just a story we tell at parties, though it's a story with important lessons about rights, accountability, and the power of standing up for what's right. My house is still sage green with cream trim and burgundy accents. It still wins compliments from visitors and passers-by. And every time I look at it, I feel grateful that I fought for it instead of giving in to someone else's vision of what it should be. That's the real victory in the end. Not the money, not the legal judgment, not even the criminal conviction of someone who abused their power. The real victory is having the home I love painted the way it was meant to be painted, and knowing that I stood up for my rights when it mattered most. The sage green Victorian on Northrop Street in Portland stands as a small monument to the principle that your home is your castle, and no one has the right to alter it without your permission, no matter what kind of authority they claim to have. That principle is worth defending, and I'm proud that I defended it.